Good morning and welcome to this morning's Knowledge Bank. Today's webinar will be hosted by Alex Clarke, Solicitor at Bolt Burdon Solicitors, and he will be discussing breaches of lease and remedies. If you have any questions throughout the session today, then please submit them via the Q&A button at the bottom of your screen, and we will try to get through as many as possible at the end. The webinar is being recorded today and will be available to watch back this afternoon with a copy of Alex's slides. That is all from me for now, and I will now hand you over to Alex to begin the webinar.
Hello and welcome to the seminar. My name is Alex Clarke. I'm a solicitor at Bolt Burdon Solicitors. Today I'm going to be talking to you about breaches of lease, the remedies available to a landlord and the recovery of legal costs. So there are many types of breaches of lease. The area is extremely broad. There are specific clauses in each lease that can be breached by a long leasehold tenant. I'm not going to be covering everything, that would take hours. So what I am going to be doing is I'm going to be going through the most common types of breaches that you probably occur in practice as a landlord or as an agent. How to identify whether a lessee is in actual breach, and how to minimise any risk to the landlord. As Vicky said, any questions throughout the seminar, please don't hesitate to ask. I will try to answer as many as I can at the end. If I don't answer any of your questions, my details will be at the end, so please feel free to drop me an email. So firstly, we'll go through the most common types of breaches. So, I mean, the ones you'll probably see day to day are alterations without consent, failure to pay service charge, which is probably the big one, subletting without consent and Airbnb short lets, failing to keep the property in repair, and using the property for a purpose that is not permitted by the lease. So in other words, a breach of the user covenant. So identifying the breach. So the very first thing that you need to do is check the lease. The lease will determine whether the lessee needs consent for structural or non-structural alterations, or whether there is an absolute prohibition on alterations. So an absolute prohibition covenant that prohibits alterations full stop. Now, the tenant can only undertake works if the landlord agrees to waive the clause or vary the lease. And a qualified covenant prohibits alterations without consent. And then a fully qualified covenant prohibits alterations without consent, such consent not to be unreasonably withheld or delayed. So usually in a lease, you'll find that structural alterations, particularly in flats, are usually prohibited, whereas internal non-structural alterations are often permitted with consent under the lease. So under section 19.2 of the Landlord and Tenant Act 1927, in all leases, whether made before or after the commencement of the Act, containing a covenant, condition or agreement against the making of improvements without a license or consent, such consent, condition or agreement shall be deemed, notwithstanding any express provision to the contrary, to be subject to a proviso that such license or consent is not to be unreasonably withheld. So what does that mean? So essentially, even if there's a qualified covenant, as I mentioned earlier, that prohibits alterations without consent, realistically speaking, because of that clause and the Act, that is essentially a fully qualified covenant. So such consent should not be unreasonably withheld or delayed. So this doesn't mean that the landlord is required to give consent. If there's a good reason he could withhold consent, only that he cannot unreasonably withhold it. So section 19.2 only applies where alterations are permitted with consent. It has no application where the lease contains an absolute prohibition. So if the works are considered an improvement, a qualified covenant will technically be fully qualified covenant, so the landlord cannot reasonably withhold consent. So before a tenant's breach can be determined, the following needs to be considered. So had the tenant requested consent to the works, and did the tenant provide the landlord with all documentation and information to be able to provide consent? What was the landlord's response, if any? If no response, has the landlord unreasonably withheld consent? And has the tenant carried out the works without requesting consent? So I think these questions are quite important because whilst a tenant, a tenant may have requested consent and not received it from the landlord, but still might be in breach if they had proceeded to carry out works without consent. This might determine how to approach the breach. A court can still make a declaration against the landlord that it has unreasonably withheld consent. So it's important to bottom out these issues before proceeding with any sort of remedy. So once a breach has been determined, a landlord must act quickly. So what I would advise is, if there has been a breach, seek advice from solicitors. I think that's the first step. So alteration without consent is a once and for all breach. I will go into this in further detail when I discuss forfeiture later on in the seminar, but it's a reason to seek instructions from solicitors. So would the landlord have granted permission if the tenant had approached beforehand? I think that's a question that needs to be asked. If so, the landlord consider a retrospective license to alter as a cost-effective remedy rather than taking sort of action against the tenant. So if the landlord does want to proceed with a retrospective license, then section 19(2) of the Act does not apply. So there's no requirement for the landlord to be reasonable when giving consent to the works completed in breach. If there's an absolute prohibition in the lease, the landlord needs to be really careful that they don't give a retrospective consent to alter, because that would essentially waive the covenant in the lease and vary the lease. So that needs to be considered. So the lease needs to be read very carefully. Careful not to waive the right to forfeit. Again, I'm going to come onto this later on in the seminar. And keep all communications without prejudice. So it can't be disclosed to a court only until the end on the issue of costs. So the next one, failure to pay service charge. So I imagine this is the one that comes up on a day-to-day basis. It's probably the most common one. So always check the lease, and this is going to be a sort of theme throughout the seminar. Always check the lease. So how is service charge to be demanded by the landlord? At what point is the service charge payable? And is the lessee liable for the charges being demanded under the lease? So, I mean, the landlord needs to be careful that he has complied with all the requirements under the lease before he proceeds with any enforcement action against the tenant. So the lease. So a lease will ordinarily provide this list here. So a description of the items the tenant is to contribute towards by the service charge, the proportion payable by the tenant, whether the service charge is variable or fixed in amount or both, whether the service charge is payable in advance or in arrears of the costs being incurred, whether the service charge is recoverable annually, biannually, quarterly or monthly, and to whom the service charge is payable, whether any shortfall in service charge is recoverable from the tenant, and whether any overpayment is to be paid to the tenant or to be placed in a reserve fund. So it's important for all these to be considered when calculating service charge payable and preparing the service charge demand. I mean, if you get this wrong and you come to enforce a demand, or you decide you want to forfeit or any of these remedies, the tenant will have a viable defence to beat the landlord's claim. So these things are very important. Always check the lease. So in addition to the lease, there's some statutory requirements. So if the landlord has complied with the lease, the landlord will need to consider the following and whether these have been complied with also. So the service charge demand must contain the landlord's name and address. If the landlord's address is not in England or Wales, an address in England or Wales must be given. So that can be an address of the landlord's agent. The service charge demand must include an address in England or Wales to which notices can be served. Again, this can be the landlord's agent's address. The service charge demand must be accompanied by a summary of tenants' rights and obligation in a prescribed form. This is probably the biggest one that I've noticed in practice, that lots of landlords often forget to provide this, and if they do, the demand is invalid. So the service charge demand cannot request payment for costs that were incurred by the landlord more than 18 months prior to the service of the demand, unless the landlord has notified the tenant in writing within that time that those costs have been incurred. So that's a very important one. I mean, the landlord cannot recover any service charge incurred 18 months prior to the service charge being demanded and the costs being incurred. So, I mean, as long as the tenant's been made aware of the charges in writing, the landlord will be able to recover those costs. But it is an important one because, you know, it could cause a shortfall in the service charge fund. So if a service charge demand does not comply with these requirements, you know, the landlord can generally remedy by serving a new demand that does comply. So it's not the end of the world, but if it gets unnoticed until the very last minute, it can cause issues if you're trying to remedy any service charge arrears. So if the landlord's complied with the statutory requirements and the requirements under the lease, and the lessee is still not paid their service charge, the lessee will be in breach. So subletting, this is another sort of big one. In terms of subletting without consent, again, you'll need to first check the lease. That's the most important thing. Similar with alterations, there are different types of covenant. So the absolute prohibition covenant, again, prohibits subletting full stop, and the tenant can only sublet if the landlord agrees to waive the clause or vary the lease. A qualified covenant prohibits subletting without consent, and a fully qualified covenant prohibits subletting without consent, such consent not to be unreasonably withheld or delayed. So again, similar with alterations, Section 19(1) of the Landlord and Tenant Act 1927. In all leases, whether made before or after the commencement of this act, contain a covenant, condition or agreement against signing, underletting, charging or parting with possession of the demised premises or any part thereof without license or consent. Such covenant, condition or agreement shall, notwithstanding any express provision to the contrary, be deemed subject to a proviso that to the effect that such license or consent is not to be unreasonably withheld. So again, what you find here is whether there's a qualified covenant in the lease, it doesn't really matter. It will realistically be a fully qualified covenant. So all leases containing a covenant against subletting without consent are deemed to be subject to this proviso. So to the effect that such license or consent is not to be unreasonably withheld or delayed. Again, there's still no obligation to grant consent if there is a valid reason. So before a tenant's breach can be determined, again, you need to properly assess how to remedy the breach. The same questions you need to ask. So, had the tenant requested consent to the subletting, and did the tenant provide the landlord with all documentation information needed to be able to provide consent? What was the landlord's response, if any, if no response? Has the landlord unreasonably withheld consent? And has the tenant sublet without requesting consent? So these questions are important again, because if you do come to remedy, you know, you need to look at what the landlord has or hasn't done, because if it does get to a court and it gets put in front of a judge, again, a judge can make a declaration that the landlord's unreasonably withheld consent, even if the tenant's been in breach. So it's important to bottom out any of these issues basically before you proceed with any remedies. Again, once a breach has been determined, a landlord must act quickly, seek advice from solicitors. So subletting without consent is a once for all breach. I'll come on to that again when we discuss forfeiture. Again, would the landlord have granted permission if the tenant had approached beforehand? If so, can the landlord consider a retrospective license to sublet as a cost-effective remedy? Again, Section 19(1 of the Landlord and Tenant Act does not apply. There's no requirement to be reasonable when giving consent. Absolute prohibition in the lease, then be careful not to grant a license. That will waive the covenant in the lease and more or less vary the terms of the lease. So you need to be very careful to check the terms of the lease. Careful not to waive the right to forfeit. I'll come on to waiver later, again in the seminar. and then keep all communications without prejudice. So it's very similar to the license to alterations. So Airbnbs and short lets, again, this is something that comes up a lot. What needs to be done is you need to check the lease. You need to check the lease to see if there's a covenant to use the demised premises for the purpose of a private residence in one occupation only, or on a similar term. So the case of Caradon District Council v Patton and Bussel. So in this case, the Court of Appeal decided that the use of a private dwelling house requires some occupation as a home. So the Court of Appeal decided that this element applies a permanence and intention to reside in the property. So the intention of the clause is basically to prevent transient occupiers, such as holiday lets. So it is accepted that the granting of holiday lets would be in breach of the lease, provided that the lease prohibits any other use aside from using the property as a private residential property. I mean, usually in all long leasehold leases, that will be a covenant. Always check the lease, but it's more or less always in a long leasehold lease. So what do you do if you find out that there is Airbnb short lets? So you need to build up the case. So you need to obtain as much evidence as possible. So essentially what you need to do is you need to find advertisements, witnesses in the block of transient occupiers, multiple different people coming and going each week and month. And has the lessee admitted the breach when approached? That's an important one. So disrepair, probably less common, but it is very important. If the reversionary interest is being damaged, the landlord needs to take action. So a lessee's repairing covenants will always be contained in the lease. So again, check the lease. A landlord will need to determine what the lessee is liable to keep in repair before bringing any sort of action against the lessee. So what I would advise doing is essentially obtaining a surveyor's report. So obtaining access under the lease, getting a surveyor to provide a report on the disrepair. So if the landlord suspects that a lessee's negligence has caused damage elsewhere in the building, so if the leaks for example, if leaks are stemming from the property, it would be necessary to obtain a surveyor's report to determine causation before any remedy is decided. So breach of the user clause. So I mean, this could be a number of different things. The answer to this question will always come from the lease. Again, similar with Airbnb short lets, you need to obtain as much evidence as possible. So that could be from other lessees in the building, or if the lessee admits the breach themselves. So some examples of that would be: does the lease restrict keeping pets? Does the lease prohibit using the property for an immoral or illegal use? So we come on to the remedies now. So these are sort of the big remedies, the main three. So forfeiture is what I'll come on to first. So forfeiture is the landlord's right to determine a lease for the tenants in breach of any of its obligations under the lease. So some examples of that are non-payment of rent, non-payment of service charge, disrepair, subletting or alterations without permission from the landlord, and breach of the user clause. So the lease always needs to be checked to determine whether there's an express right in the lease to actually forfeit. So for example, the lease may provide that the landlord is entitled to forfeit the lease for the failure to pay rent within 14 or 21 days of the due date, or on the occurrence of a specific event detailed in the lease. So for example, if the lessee becomes insolvent, there might be a clause in the lease that allows the landlord to forfeit on that basis, or for any other breach of tenant covenant. So some of the procedural considerations that needs to be considered. So again, is there an express right to forfeit in the lease? So that's the most important one. If there isn't, you know, it's not certain as to whether you can actually forfeit. As the right to forfeit arisen, is there a grace period? So, you know, a lessee is not going to be in breach of the lease for not paying the rent the day after it's due. There's usually a 14 or 21 day, you know, period where after that period, then they'll be in breach. So is there a grace period? Does the landlord need to have complied with any terms of the lease to be able to use the forfeiture provision? So, for example, have you served the correct demands, the service charge demands, the rent demands? Have they been served correctly and in accordance with the lease? Has the landlord waived forfeiture? We'll come on to waiver shortly. Does a section 146 notice need to be served before forfeiting the lease? So for non-payment of rent and service charge or any other administration charge under the lease, court proceedings must always be used. If it's a residential property, you cannot peaceably re-enter the property. You always have to use court proceedings. So demands must have already been served on the tenant and in correct form. So as earlier we went through the statutory and the lease clauses that need to be complied with. So is there a grace period? Again, when does the right come about to forfeit? So under the Common Hold and Leasehold Reform Act 2002, the amount of rent, service charge or admin charge must be over £350 or outstanding for more than 3 years. So the upper tribunal held in a case called Shearer Mate 2 v. Cals, the prescribed period of 3 years runs from the date of the rent demand notice in relation to ground rent. So a landlord cannot forfeit the lease unless a court or the FTT, so the first tier tribunal, has finally determined the breach or the tenant has admitted the breach themselves. And once determination by the court has been made or the lessee has admitted the breach, a section 146 notice will need to be served on the tenant if forfeiting for service charge or administration charges. But a section 146 notice need not be served in the cases of unpaid ground rent. So any other breach, again, court proceedings must be issued if a property is occupied as a residential lease. All court proceedings always need to be used. You can't peaceably re-enter, you can't change the locks, that just can't happen. So the tenant must have admitted the breach, or the court or the FTT must have finally determined the breach. And a section 146 notice will always need to be served if it's relating to any other breach aside from service charge. So disrepair cases. So these are special cases. It's not the usual sort of procedure. So the Leasehold Property Repairs Act 1938 needs to be complied with. So it will apply to any lease granted for a term of 7 years and 3 years remaining. So that's most long leasehold leases. A section 146 notice must inform the tenant of his rights under the Act. Then the tenant has 21 days to serve a counter notice. If no counter notice is served, you can proceed as usual, as you would do any other breach. If a counter notice is served, then the landlord needs leave of the court to proceed with forfeiture. And leave is only granted in limited circumstances. So some of these are the conditions for leave, and you know it is a strict criteria. So the first one is the immediate remedying of the breach is necessary to prevent substantial diminution in the value of the landlord's reversion, or its value has already been substantially diminished. The immediate remedy of the breach is necessary to comply with any enactment or bylaw or similar matter, so planning or building consent or anything like that. the tenant is not occupying the whole of the premises affected, and the immediate remedying of the breach is necessary in the interest of the other occupiers. The cost of immediately remedying the breach is small relative to the costs occasioned by postponement. And finally, there are special circumstances which make the giving of leave just and equitable. So this one, it will depend on the court, the facts of the case, and realistically, it will depend on the discretion of the judge and the court. So Section 146 notices. So a Section 146 notice prevents enforcement of the right to forfeit unless and until requisite notice is served. So the notice must always be served by the lessor, the landlord, on the lessee. It must specify the breach and must require the lessee to remedy the breach if capable. There's no need to specify the remedy, just that to remedy the breach. So a breach capable of remedy must be within a finite period of time. So the landlord must give the lessee a reasonable amount of time between the service of the notice and actually forfeiting the lease. So realistically, a reasonable amount of time depends on the facts of the case. It could be, anything from 7 to 14 days is the most common, but it could be more if it's, more of a technical breach. Again, always forfeit the lease by court proceedings if it's a residential property. So some of the advantages of forfeiture. So, realistically speaking, forfeiture is a draconian remedy. You are essentially taking somebody's leasehold interest away from them. It's a very harsh remedy. So the threat of forfeiture is a strong tool to put pressure on tenants and mortgagors to comply with the lease. A mortgagor will not want to lose their interest in the property, and they will pay the arrears or put pressure on the tenant to remedy any breach. And if you keep all accounts up to date to show the court when determining the breach, it will avoid a disputed hearing. Some of the disadvantages: a tenant can apply for relief from forfeiture immediately. So provided that the breach is remedied, relief from forfeiture will most likely always be granted. The FTT is unwilling to forfeit a long residential lease. The court's always inclined to make allowances for the tenant, so that they are able to remedy the breach. Forfeiture really is a remedy just to force the tenant to comply with a lease. That's how it's usually used. And finally, I think the landlord needs to ask itself, is it in the landlord's commercial interest? How long will the property be vacant for? There's going to be a shortfall of service charge and rent. What's the current market like? Can a new tenancy be granted on superior terms or alternatively on lesser terms? So those need to be considered before proceeding with possession. So now we come on to waiver. So, this is quite important for landlords to be aware of. So waiver is an absolute defence to forfeiture. So when you forfeit the lease, you're essentially saying that the lease no longer exists because of a breach by the tenant. So a waiver will occur when the landlord, with knowledge of the breach, commits an act that expressly, impliedly recognises the continuance existence of the lease. So when a breach occurs, a landlord must consider whether to enforce the right of forfeiture and treat the lease as being at an end, or treat the lease as continuing to exist. If you do treat the lease as continuing to exist, obviously you'll then waive the right to forfeit. So it is advisable to keep all correspondence without prejudice if the tenant breaches the lease. More importantly, with forfeiture, always seek advice from solicitors before taking any action against a lessee when they have breached the lease. I think that's the first sort of port of call, just in case you accidentally waive the right to forfeit. So the three conditions of waiver: so the landlord's knowledge, so knowledge of the basic facts, which in law amount to a breach of covenant. Knowledge can be acquired by an agent, employee, or of the landlord, or where the agent has a duty to report the matter to the landlord. If a landlord has suspicion, but is assured by the lessee that there is no breach and no breach has occurred, that will be no waiver. There has to be absolute knowledge. The unequivocal recognition by the landlord of the continued existence of the lease. So the intention to waive forfeiture is unnecessary. If it's waived, it's waived. And receipt of rent without prejudice, that would also be a waiver. If you receive rent, that's a waiver. You're supposed to basically say that the lease doesn't exist. So the acceptance of rent, that goes against that. And finally, some form of communication of that recognition to the tenant. So, any form of email to the tenant recognizing that the lease exists, that would be a waiver. So some examples of waiver. So accepting or demanding rent, granting a license for subletting, alterations, serving any notices under the lease, requesting access as per the terms of the lease, communicating with the tenant in a way that recognizes the lease exists. That they will all be a waiver of forfeiture. So continuing or a once and for all breach. So there are different types of breaches. So a continuing breach happens where a right to forfeit will arise every day regardless of waiver. And a once and for all breach, once it's waived, the right to forfeit is lost for that breach. So it's very important for a once and for all breach that you don't waive and lose the right to forfeit, because it is a very good remedy to force the tenant to comply with the lease. So some of the examples. So in a continuing breach, illegal or immoral use, usually user covenants in the lease, that's usually a continuing breach. Failure to keep the premises in repair, that's also a continuing breach. Once and for all breaches, non-payment of rent, and then unauthorized alterations or subletting or anything like that. So the landlord's obligation. So this is important because it's a bit of a minefield forfeiture, and it's often not clear how to approach a tenant if they have breached a lease and whether the landlord can still comply with their landlord's obligations under the lease. So there was a case of Stamp v6 Ladbroke Gardens Management Limited. So a landlord will not waive the right to forfeit in the event that the landlord relies on the lease terms to perform its own obligations. So in this case, there's a Section 20 procedure for major works. Notice was served to all tenants, including the defaulting service charge tenants, in the consultation process. That's one of the landlord's obligations. That was considered not a waiver. The fact that the landlord had consulted the lessees about the proposed repairs is not sufficient. The landlord is still bound by its repairing covenants. The enforcement of the fire authority statutory notice, that's also not a waiver. The landlord had relied on covenants in the lease regarding fire safety arrangements and allowing entry. So, at that time, the lessees continued to be leaseholders, and the landlord continued to have responsibilities regardless of the state of the building. However, in this case, it was deemed that the landlord did waive forfeiture because he demanded the service charge for the works, and that was considered a waiver. So costs, who pays? So usually in most leases, if you have the right to forfeit, there'll also be another clause to say that the lessee will pay to the lessor all costs, charges and expenses at any time during the said term incurred by the lessor in contemplation of any proceedings in respect of the lease under sections 146 and 147 of the Law of Property Act 1925. So essentially costs incurred for determination of breach are incidental to preparation of a notice under section 146, and therefore all those costs should be recoverable from the tenant. However, In proceedings, the landlord must show that forfeiture was being contemplated at the time of incurring legal costs. So you can, seek recovery of service charge in the county court and seek a declaration that the tenant is in arrears. But you must then show that of the intention that forfeiture is being contemplated, and a section 146 notice must be served. It's important to note that obviously the landlord is unlikely to be indemnified for all costs unless there's an express provision in the lease. It's unlikely that the landlord will recover all costs. So injunctions. So this is another type of remedy. So a landlord can apply for an injunction requiring the tenant to remedy a breach. So this remedy is usually used in cases of alterations without consent, subletting without consent, and potentially disrepair cases. And there are two types of injunction. So there's an interim injunction. This is used in emergency situations. This is a temporary remedy. So if you go for an interim injunction, it needs to be a complete emergency, and also you need to proceed to trial or settlement. You can't request an interim injunction and leave it at that. You need to proceed with full injunction. And then you have the ordinary claim for an injunction for less serious or less of an emergency. In injunction claims, a landlord can claim for damages at the same time, and it's always advisable to do so. So, costs. So, an injunction will be made in the county court. So, a contested claim of this sort of nature, illegal costs could well exceed £50,000 plus VAT. They are very costly. If it goes all the way to trial, they are very costly. So the court has a discretion to make an order that the unsuccessful party pays a proportion of the successful costs, and that's usually around 65 to 75% of the actual costs incurred. So debt claims. I mean, I'm sure a lot of you have experience in these sorts of claims, particularly for service charge arrears. So for breaches of lease, such as unpaid service charges or rent, the landlord has the option to bring debt proceedings against the lessee and enforce the judgment of the debt. Again, before you proceed with any of this, the landlord needs to be satisfied that they complied with the requirements in the lease and the statutory requirements regarding the form of any demands. So if the tenant raises a defence on this basis, the claim might well fail. So that's really important to do before you proceed with any of this. So the landlord would have to comply with the pre-action protocol. And the purpose of this is essentially, you need to understand each other's position, decide how to proceed. Can you settle? Can you use ADR, alternative dispute resolutions? And it's to support the management of the claim and also to reduce costs. So to start a debt claim, a landlord must serve a letter of claim on the defendant, the lessee. It must state the amount, any interest. You must enclose a copy of the lease. Is there a guarantor? That needs to be considered. You also need to set out why instalments are not acceptable and why you need the entire sum. How the debt can be paid. You must enclose a statement of account and any demands that have been served on the tenant. And then you must enclose a reply form and information sheet for the tenant to use to reply. So after the letter of claim has been sent, you must wait 30 days for a response plus any reasonable extra time. If no response, issue court proceedings. If it's not been defended, request the judgment. Send the judgment to the tenant and the mortgage company if the landlord wishes to recover debt from the mortgage company, and then serve as section 146 notice if that's what the landlord wants to do. With these, you can sort of always go in circles. I recently had a client where they were going in circles doing the debt process over and over and over, And sometimes it's often a case where you need another remedy. And if a debt gets up to £25,000, you know, if you've got major works and you've got other service charge amounts, you've got judgments rolling over, it may not always be advisable to seek payment from the mortgage, or, you know, you can take steps to put a charging order on that and force the sale if it's a certain amount. So that's always something that can be considered. So cost recovery in debt claims. So again, always check the lease. There may be a clause in the lease that allows you to recover your costs. If there is a clause to recover costs in contemplation of forfeiture, which I've set out earlier in the seminar, this can be used to recover costs, provided that the landlord can show the reason for the debt claim is to serve a Section 146 notice to forfeit the lease. If there is no clause in the lease, you know, the claim will be treated as either a small track, fast track, or multi-track claim. So if you are seeking to recover service charge under £10,000 and there is no clause in the lease to allow you to recover your costs, you're only going to obtain fixed costs. So that would be the cost of the court fee. So that's something to be aware of. So a standard form of long lease will have a clause worded similarly to the following. So the service provision shall consist of a sum comprising all fees, charges and expenses payable to any solicitor, accountant, surveyor, valuer or architect whom the landlord may from time to time reasonably employ in connection with the management or maintenance of the estate, including computation and collection of rent, but not including fees, charges or expenses in connection with the effecting of any letting or sale of any premises, including the cost of preparation of the account, service charge, and if any such works shall be undertaken by an employee of the landlord, then a reasonable allowance for the landlord for such work. I mean, these clauses can be worded differently. I think you should always seek advice from a solicitor who will be able to, you know, review the lease and advise you as to whether cost recovery is possible. So recovery of costs in the FTT. So if you decide to proceed down the first tier tribunal, you need to be aware that the FTT is a no cost tribunal. So essentially that means there will be a no award to costs only in exceptional circumstances, or if there's an express term in the lease. So that needs to be considered carefully, because if you rack up lots of costs in the FTT and there's no clause in the lease to recover costs, you're not going to get any costs back. The tribunal has the power to order the leaseholder to pay a landlord's costs if the leaseholder has been unreasonable in bringing, defending or conducting proceedings in a residential property case. However, the test for unreasonableness is extremely high. It's not often that a tribunal will make an award for unreasonableness. So, you know, I wouldn't sort of bank on that clause to try and recover costs. So recovering costs in the FTT as service charge. So if the lease allows you to recover costs through service charge, then you're able to. However, the leaseholder can make an application pursuant to Section 20C of the Landlord and Tenant Act 1985 for an order preventing this from happening in whole or in part. So if that does happen, the FTT can make an order which it considers just and equitable in the circumstances. So, you know, it could make an order that only 50% of legal costs incurred are recoverable via the provisions of the service charge. And that is the end of the seminar. My details are here if you need to get in contact with me. I will just check to see if there's any questions. Do leases need to have a specified forfeiture clause? Yes, there will need to be a clause in the lease. If there is no clause in the lease, then, you know, there's nothing to rely upon in court. So yes, you will need a forfeiture clause to be able to proceed with forfeiture. what would be an example of a statement of the tenant's rights and obligation, and what is a prescribed form? If these conditions have not been met, can the service charge demands be challenged? Yes, I mean, they can. I mean, you should be able to obtain the prescribed form on, you know, on the internet. You should be able to get some form of precedent. If you haven't served the demands with the prescribed form, then yes, the demand will be invalid. Given the Duval case, if there is an absolute prohibition, I'm not sure if the 1927 Act applies, as many landlords give blanket bans on any alterations. I would have to consider that in a little bit more detail. So Andre, if you want to email me after this seminar, we can then discuss that a little bit further. Okay, I think that's all the questions. Vicky?
Hi, Alex.
Hi.
That was really well received. Thank you. I think that went really well. Yeah, I can see there's no more questions. I will be sending all of you a copy of the slides and the recording this afternoon. The slides have obviously got Alex's contact details on, so if anyone would like to follow up with him directly, you will have that information there ready for you. We will be back next week with another 2 webinars from Bolt Burdon. On the 26th of April, we will be discussing private sector possession proceedings. And on the 28th of April, we will be discussing the commercial rent coronavirus bill. So if anyone would like to join us for either of those sessions, then please register via the News on the Block website. Otherwise, thank you so much for joining us today. Thank you, Alex, for your time. And enjoy the rest of your day, everyone.
Thank you.
Thanks, Alex. Bye.
Bye.